Hi, I'm Janice Switlow. Today I have a very serious topic to discuss with you. And to begin with, some of you may not be familiar with the Doctrine of Effective Control. This is a doctrine that the Government of Canada says it's relying on in terms of dealing with the Indian question, if you will. What's the Doctrine of Effective Control? Quote, in effect, a government that comes into power through coup d'etat or any other unconstitutional means would be recognized as legitimate as long as it is in control of the state. So some entities that have relied on this include Libya and other Middle Eastern entities, African, Haitian, China, and Russia right now is exercising and relying on this doctrine as well. So you can see how I was shocked to read on the official website a statement published by the Department of Justice that says, in terms of the Government of Canada's relationship with, I think, Indigenous peoples or Indigenous nations or Indigenous groups, you get the gist. It depends on assertion of sovereignty. Now, we're very familiar with that. I've spoken about that at length. Assertion of sovereignty, but the new statement, which was always understood they were doing, but never had they gone public before to admit this, Department of Justice also said relying on effective control. So there's some other developments that Canada and the courts, the Canadian courts, have put in place that essentially they're trying to say at this moment in time, the Indigenous nations are gone. There is no more Indigenous sovereignty. As a result, there are also no more treaties in effect. Now, it's important to understand that that statement by the Department of Justice was not speaking of the Crown relations with Indigenous nations. It's speaking about the Government of Canada's relations. And it's important to understand, by adopting this approach of effective control, when there are actually treaties in place with no exit provisions, treaties in place between Indigenous nations and the Crown, that these Department of Justice lawyers, which are technically Crown lawyers, at least they're supposed to be. So what these Crown lawyers, Department of Justice making this statement, they are actually, as I said, because there's treaties in place, they're actually acting like a revolution against the Crown. This is very serious, not just for Indigenous nationals, but for all Canadians. Because Canada is saying that in order to satisfy the world that with certainty Canada controls all of the natural resources, for example. And, if you recall in my previous videos, I've said, look, under the treaties, for example, mining, as long as it's done by the Crown itself or through her governments, but it cannot extend any permissions to third parties, and corporations are not subjects of the Crown. So Canada's trying to assure industry that, no, you only have to deal with us. You don't actually have to get those permissions from Indigenous nations, like Switlow says. Because why? Well, we're relying on the Doctrine of Effective Control. Now, remember this doctrine, and you Google it, you can read about it. This doctrine is essentially an unlawful, unconstitutional means of saying, we're just taking this. Like I said, notwithstanding the fact there are treaties which grant, whenever you see a treaty with the words to have and to hold, you now know, of course, that signals this is a leasehold kind of interest. The Crown has become the head tenant. But it specifically recognizes the sovereignty of the Indigenous nations that are the party, as well as obviously their ownership of land. And I've been very clear that the treaties didn't grant any permissions over water, and there is no water treaty. Water is very critical because in terms of the development of so-called green hydrogen, the technology doesn't exist yet. It's actually blue hydrogen that they are able to obtain. What that requires is not just diversion of water, it actually requires using up the water because it splits the water into hydrogen and oxygen. And so it's not like run of river where it's diverted, you generate some electrical power, turning the turbines, and then the water comes back. There's a little bit of loss, but not significant. This is completely different. And so you'll see Canada has been setting up as I pointed this out and reminded the Crown of this, instead of responding in the honorable way, and that is approaching the Indigenous nations and seeing if they're willing to provide some permissions or if they're willing to enter into a treaty, not a domestic agreement, a treaty regarding water use. Instead of doing that approach, the government of Canada has said, no, we're going to just double down and assert our ownership and effective control in order to secure those assets. It's not usually effective control, relying on that doctrine, is after there has been a war, civil strife, violence, and such. And now you have, a coup d'etat, when you have someone then in charge but hasn't been put there by the people, isn't there because of the constitution of the country, isn't there because of any lawful means. So for years now I've been speaking about Canada as an outlaw nation. Well, an outlaw nation, sad to say, that now is relying on effective control, the doctrine of effective control, to try to finish taking. Now remember, we have the Section 35 doctrine. That's a domestic doctrine. The doctrine of effective control is an international doctrine, but it's received such criticism, lots of academic work and analyzing it, to say this is not to be encouraged. And certainly, this is where this has happened, Africa, Middle East, as I said. Russia is now trying this with Ukraine. Yet ironically, the government of Canada is supporting Ukraine and pointing the finger at Russia with confidence that no one really knows what's going on in Canada. That Canada itself is now linked with Asia and all of the things that happened after the fall of the Soviet Union in terms of structures coming into place. That's not what I've ever expected would happen in Canada. Naively, I guess, I expected that by explaining the legal realities on the ground here, what are the facts, that the simple process of complying with the rule of law, because of course relying on the doctrine of effective control ousts the rule of law. So we have this dichotomy here, this in terms of when you look into this stuff, the other thing that's related to this, it's a separate kind of doctrine, but it's called legitimacy, whether it's a legitimate government. And I had to laugh because there's a number of categories of that, one of which is called the charismatic leader. So it's not a lawful or legitimate means in and of itself from a legal constitutional perspective, but you have a charismatic leader. And I put it to Canadians and I put it to Indigenous nationals with relations still with the Crown, that having a fancy selection of socks and having good hair and good smiles and a nice, not saying much, but smiling nicely and looking compassionate, those aspects of a charismatic leader are completely insufficient for a constitutional rule of law governed nation. Canada, which has been as a result of permissions granted to the Crown to provide limited partial sovereignty, that through that permissions which are specific and personally held by the Crown, he then permits the governments of Canada to function. But what the government of Canada is doing is saying, no, we're not going to be limited by that. Because Canada can't get more than what the Crown has. And the Crown is bound by the treaties. For example, treaties 1 to 11. Canada's saying we don't care about that. We're going to base our economy on getting at those critical minerals and getting at that water and getting at these resources that in and of themselves they do not have the lawful ability to just take. And they're finding that the Section 35 doctrine that I've been exposing for decades now, there's not a lot of people still really keen about that. They're starting to really understand what that is. So that next step off, as I said, is to say, well, okay, we'll have to rely on this international doctrine of effective control. In my book, Gustavson Lake Under Siege, which came out in 1997, I think it was, I ended it with this, when I explained what was happening and being done to indigenous nations. You remember the green light to kill was the order. Fortunately, the officers involved missed their targets. As it was conveyed to me personally by some of them there, that it was interesting how without anyone saying a word to each other, no one was prepared to kill those who were conducting a Sundance at Gustavson Lake. But they were ordered to do that. So I ended that book by saying, so who's next? The premise being that you can't turn a blind eye to what's being done. The continuing genocide. I used to just call it continuing attempts to colonize. But the continuing, and the eve that we have the House of Commons of Canada admitting and declaring that residential schools, that was genocide. Right after the Pope has said, yeah, I see that as genocide. We have everyone admitting that. And we have the Department of Justice saying, well, the foundation for Canada is a reliance on the doctrine of effective control. I ended that book saying, so who's next? It's all of us. Now, people have been disturbed by, for instance, the exercise of emergency powers under the Emergencies Act recently, the inquiries going on right now. But I put it to you that this confirmation that what they are doing to Indigenous nationals who also carry Canadian citizenship, not because they asked for it, but because Canada deemed them to be citizens, that therefore what is being done to one part of the citizenship will also be even that more easier to be done to all of us. And to live in a country that states its existence on the doctrine of effective control is frightening. It really is. Now let me also share with you how Canada is kind of backing this whole thing up. Because you have bands who decide to go into final land claim settlements or self-government agreements. And all of those say, yeah, you're under Canada. Section 35 applies. You are a creature, and indeed, federal legislation will create and incorporate a new body that becomes the government. That's clearly a Canadian government. Others just say, no, we're not going to do that. We're Indian bands. We're here, but you're not safe there either. Because how Canada and the courts have structured that is to say that, oh yeah, the Charter of Rights and Freedoms applies to Indian bands. Used to be that Indian bands were seen as federal boards. That's long-standing case law. More recently, though, the courts are saying, well, the Charter applies. Now, every single self-government agreement and land claims agreement contains provisions, in the past at least, that the Charter will apply. That was necessary because these are not Canadian entities. Remember, the Charter only applies to Canadian governments. So an existing Indigenous nation is, before Canada deemed its nationals also citizens of Canada, they were considered foreign nationals. That was why you had to try to get them to enfranchise. That didn't work. So now deemed citizens, and now saying that their bands are actually Canadian governments because they're saying the Charter applies. And you'll notice the change of language in statements on the Canadian government's website. Things like, the Charter will continue to apply. Whereas before, and speaking about, for instance, self-government agreements, before Canada would say, the Charter will apply. So now Canada's saying, no, we've got enough under the court's decisions to say, yeah, actually, the Charter does apply. They are Canadian governments. And the Canadian Human Rights Commission also applies. And while there's some benefits to that, it actually, I see now, was a lead into this next step of saying, well, they're actually Canadian governments. So Canada then thinks it's got everything wrapped up, whether you go into and on the agreements or not, or remain Indian bands or not. They think they've got you every which way. But here's the problem. By saying that the Indian Band Council, not the members, by saying the Indian Band Council is a Canadian government, these band councils, and sometimes it's just the signature of the chief, these band councils are part of the Canadian government. So if you follow me here, Canada cannot negotiate with itself, an entity beneath it, in order to terminate a nation, in order to terminate an Indigenous nation, terminate treaties. Canada's saying, well, we don't have to do that because of the Doctrine of Effective Control. We've got them. They've signed off. They've recognized us. Every single agreement that's done these days all has a reference to Section 35. That's an admission that you're underneath Canada. And so the problem with all of this, and this is why Canada is relying on Doctrine of Effective Control, is that there is no Canadian government that can commit and make a decision for the Indigenous people. They are under their continuing sovereign constitutions, and I've seen, across everywhere, I've seen they still function. They may be smaller in number. A lot of people don't understand, what Canada is doing, but it still functions. And almost daily I have people contacting me to say, we don't really know what's going on up here. We know something's wrong with us. We don't understand this new step of colonization that they're doing and things like this. Well, it's because it's important to understand that Canada's saying today essentially it doesn't matter what Indigenous nationals do. If you look at it, world, we're in control. We have effective control. Never mind those treaties. Never mind that, Crown only has a tenancy. We say we have more. We're just going to take it. Now, in terms of any investors in Canada, this is not what you'd call a stable democracy with where you'd want to park your money and develop assets. Because if you've got any government acting without, without respect to the rule of law, acting unconstitutionally and unlawfully, acting contrary to its head of state, that's the epitome of the volatility. And so this is now down to kind of stack, right? What's been signed, who signed them. But if it's always a Canadian government signing these agreements, and the people haven't voted on them, they don't even know about them, how the heck can you possibly suggest to anyone that that's a lawful approach? It's not. Let's be clear. It's using a few people to create an end result. Whether they understand what they're doing or not is beside the point. Under the honor of the Crown, and especially the Department of Justice lawyers, who have that responsibility to uphold the law, the rule of law, to outright say, yes, it's only assertion of sovereignty, and it's only the doctrine of effective control. That's how it is. We can say, you only have to look to us. And I strongly recommend to anyone considering any development, mining, anything of that nature in Canada, to know that's the environment, that's the unlawful environment that you're considering operating within. Now, will Canada go to the end result of declaring, well, it's already a declaration of war. Back in one of my papers on continuing attempts to colonize, I said, look, it's like a holy war. It's like a Cold War. And this has been happening. It's still happening. Only we're now at that kind of end result where the government of Canada having been boxed into corners, if you will. You can't deny what the treaties say and are. And you have Indigenous people who are becoming informed and starting to know and question these things. They're not the good little Indians being told what to do anymore. It's easy still to manipulate them, yes. And this is happening. But, if you come across and say, okay, we're going to use a band council to achieve these results, you can't then declare they're a Canadian government, because it's Canada dealing with Canada. There is nothing in that formula that is providing consent and capitulation and abandonment by the Indigenous nationals. Now, is this going to be an easy road? Well, heck no. Any population's been subject to genocide, and even recognizing that genocide happened, the reality in Canada is it's still happening. And Canada is going to try to move the doctrine of effective control into environments that don't include violence and war and outright physical violence and coup d'etats and things of that nature. It's going to be possible to do it by, agreements and misleading people and not having, and keep in mind, Indigenous nationals do not have independent access to legal advice in Canada, because lawyers, as determined and decided by the law societies, dictate that the lawyers must accept instructions for a band only from chief and counsel. Now, as former Department of Justice in-house legal counsel for Indian Affairs, I can tell you there's a long history of petitions to the Crown, informing the Crown of issues that exist, not brought by chief and counsel, but brought by band members. That was a very common way of doing things. But when I came out into private practice and did the very same thing that I did as a Department of Justice lawyer, Law Society freaked out and said, no, we can't have access to justice for band members. We have to control that. So sadly, it was my efforts to protect a band from the very actions of its own band council that led to that result, that lawyers have to take instructions from chief and counsel only. That means there's only lawyers for Canadian governments, because remember, Canada is saying, the courts are saying, the charter applies. Charter only applies to Canadian governments. So there are no lawyers, there is no access to justice on every level for Indigenous nationals in this part of the world. That is not lawful. That is part of the law societies, the lawyers. They are part of this effective control application. Is that any surprise? Well, no, not really. It's not what lawyers are supposed to be doing. I'm the anomaly. I practiced law for 10 years, and I've taken a number of oaths to protect the interests of the Crown. The interests of the Crown being treaties, for instance, protecting that head lease. So in the course of protecting the interests of the Crown, I also protect the interests of the Indigenous nationals. They have that relationship. But what the governments of Canada and the provinces are doing, now keep in mind the provinces too, like Alberta and Saskatchewan, they're busy trying to say and assert their jurisdiction. No, we control it. because they want, the critical minerals and all that stuff to happen, the mining. So the provinces themselves are saying Canada is just asserting jurisdiction. Canada is just exercising this effective control. So the provinces are doing their best to demonstrate, no, we have that. They're trying to protect their aspects of the divisions of powers under the Constitution. So for people who are wondering why is that all happening, it's because the government of Canada is this outlaw nation. And it's not just vis-a-vis Indigenous nations. It is now allegedly, because that this is happening vis-a-vis provinces too. So my prophetic words as to who's next back in 1997, we can see that now it's all Canadians. And we can see that Canada is aligning itself with countries whose actions I don't expect any, or very few at least, in Canada would want our governments to follow their example. So Canada is not only following that example, but expanding it to say, it's okay to do this. It's okay to, because the ends justifies the means, right? At the end of the day, we'll have the water, we'll have the ability to mine, we won't have to get any permissions, we can just do this. How is that going to serve Canadians? If the actual owners of the property can be treated like this, where does that leave us in terms of the rest of the Canadians here involved? As I said, very, very scary. That's all I have to say for now. I will be setting out really the history of how this doctrine of effective control started to be used, if you will, in Canada, and also what's wrong with that picture. But that's going to be once I have a new book that will be released soon. And that's because this is the 25th anniversary of Gustafson Lake, the Under Siege, my book release. This is a 25th special edition that will update what has happened since that time, and how Canada has, instead of heeding the warnings, instead of acting in that very simple, lawful way, has chosen a very, very dark route. And that's why I say this is a very, very unbelievable and unexpected point in time for Canada. And it's very disappointing, to say the least. And it's my sincere hope that the international community will not endorse and follow Canada's attempt to expand that doctrine, while most academics in most countries are saying we really don't have a place for that doctrine. Only in very rare instances where there has been a conclusion of war and certain things have occurred does it make sense to look at and recognize that government. That's not appropriate for Canada, and that's all I have to say.